All right, so EJ, in the civilian world, you get charged either through an information or an indictment that usually comes out of a grand jury. In the military, it's different. What is the charging document for a court-martial in the military?
And the charging document in a court-martial is called a charge sheet. It's basically a form. It's got the service members' information across the top, like administrative information, name and unit, rank, what have you, pay information, and then goes down into a section for offenses that are alleged to have been committed.
And that's where the government lists every charge against that particular accused,
right,
so that they know what they're facing.
That's right, and they're grouped by charges, and then underneath there's actual specific things called specifications. So basically, say charge 1 is violation of the UCMJ Article 120. Okay, that's rape and sexual assault. Underneath that, there would be specification 1, specification 2, specification 3. On this date, service member did this, and this, and so on and so forth.
Okay, so that's where all the known criminal behavior goes on to the charging document.
Yes.
Now, as a defense lawyer, one of the first things I want to see in a court-martial is I want to see that charging document. All right. And what are the things that a military defense lawyer should be looking at when examining that charging document?
You got to look at all the charges, see if they even state an offense. Sometimes they don't, and that's grounds for dismissal of the charge. So if it says Private so-and-so looked at me funny, that's not an offense, so that gets dismissed. Another thing you have to look for is whatever they've charged the soldier with, gotta make sure every element of that offense is in there. Every offense has certain elements, and the government has to meet all of those before they can get a conviction on that.
And they have to be charged, right?
Yes.
So when I get a charge sheet, I pull out the Uniform Code of Military Justice, the Manual for Courts Martial. I flip to that section, and there is a sample specification with the elements. And I pull out that, no matter how many times I've read that, and I look at the charge, and I compare it to the sample specification to see whether or not the government's added language or did something kind of funky. And then the next thing I do is I check off to make sure that every element has been met for each one of the charges on the specification.
Right.
And that's just to make sure that it's been charged correctly and that the government has done what they're supposed to do.
Exactly.
Okay. What else can you learn from a charge sheet in the way the government has charged a case?
Well, you can learn a lot of things. Obviously, you learn what the service member has been charged with, what they actually think the service member did. If there's anything else out there that they may have missed. As the defense counsel, you and your client have a unique relationship where they can tell you things and you are not allowed to tell anyone else. Right. So there might be things floating out there that the government doesn't know about yet. And so that's that factors into a strategy too.
So one of the things that I always do is I have my client go over the charge sheet and explain each charge to me. Explain in layman's terms. I actually tell them to write a narrative about that specification, about what happened before, during, and after, and don't leave out any details. And of course, this narrative, they put on it, it's attorney-client privilege and information, and so we work off the narrative off of each specification. And that's the starting point for trying to understand what the misconduct really is.
Yeah.
And sometimes the narrative doesn't match up with what the specification is.
That's right.
Right. I'll tell you, one of the cases that I recently reviewed, and when I say recently, within the last year, the government failed to charge intent on a sexual assault, okay? And this was one of the specifications that required intent to be specified. And I had to make a decision. Do I raise that to the military judge now and allow the government to fix it, or do I hold it and wait until Jeopardy has attached and then raise the issue? And the reason I would have to do that is because if I raise the issues early, the government can dismiss and re-refer and fix the problem. If jeopardy has attached, meaning the trial has started and a witness has begun to testify, then the government can't fix it.
Right. As soon as there's evidence of any kind entered, the government can't fix it.
And so in that case, I had made the decision not to bring it to the attention of the government. And so the military judge, when preparing for trial, sent out an email asking the counsel to brief why this particular specification stated an offense, which I took offense to because part of our strategy was to wait until jeopardy attached and then move to dismiss. Whereas the military judge, by sending out this email, signaled to the government that their charge was defective. And so what wound up happening is the government withdrew the charges and re-referred them at a later date and moved the trial back.
So the judge helped them fix their mistake.
In that instance, the military judge helped them fix their mistake. But that's part of the military practice. The military judges are quite paternalistic in the military. And what they see their role is not just a military judge, but to also, to some degree, ensure justice is done, which is not the way it's done in the civilian world, and really not the way it should be done in the military. But that's been my practice.
Yes.
My name is Will Helixon. We're the law office of Will M. Helixon, your warrior advocates. You defend the nation, we defend you.